right, looks like we have everybody connected. So we'll go on the record now. This is Peyton Jones versus Munson Healthcare et al. This is file number 2319251 NH. And if I could have all counsel put your appearances on, starting with plaintiff.
Good morning, Your Honor. Rebecca Walsh appearing on behalf of baby Peyton Jones and her parents.
Good morning, Your Honor. Jennifer Sikorsky on behalf of the plaintiffs.
Morning, Judge. Ralph Valatutti appearing on behalf of June Murphy, PC, and June Murphy individually, Dr. Ronald Janette, Dr. Jessica Kiley, and Dr. Minor.
Yes, good morning, Your Honor. Jenna Wright-Greenman appearing on behalf of Otsego Munson Healthcare.
Okay, great. Thank you. We're on the record this morning. We've got a lot to do here. We've got 6 different motions set for hearing today. Just want to set a couple just ground rules before we get started with oral argument here. Because we do have so many different motions, I'm going to ask counsel to be as efficient as possible with your arguments today. There were voluminous materials submitted, and I'm not saying that as a criticism. I think they were all good materials. I thought the briefing was very good on behalf of all parties and certainly helpful to me in understanding the issues and formulating rulings for these. But that being said, there were voluminous materials, and I read through all the depositions, looked through the documents that were submitted as exhibits. So I really don't need counsel to spend a lot of time rehashing what's already in writing or the facts of this case. Having read all those depositions, I feel like I've got a really good understanding, as good as a layperson can have, about the medical issues here and the doctor's opinions, various doctors' opinions. So I want counsel to be aware. I've read through it all. I'm ready to rule on all of these motions here from the bench today. So I really don't want to spend a lot of time just rehashing stuff that's already in there to keep things more efficient. So I'd really like counsel to focus your arguments on the various responses and reply briefs and your responses as responding parties. I do have a plan for how I kind of want to proceed through this, just based on my process in going through the motions. So I'd like to address the motions for summary disposition first. And the first one I'd like to address is, defendant's motion for summary disposition as to Dr. Murphy and her PC. And so, Mr. Valatutti, your oral argument as to that motion, please.
Thank you, Your Honor, and I'll try to keep this as brief as possible, recognizing and thanking the court for what must have been a great deal of time that took up the court's attention. Dr. Murphy was an independent contractor. She's one of 4 defendants that I'm representing in this case. She is a maternal fetal medicine specialist, and her role in this case was as a consultant. And she was called upon just once. It's in the plaintiff's papers that she was called upon twice. That's not correct. She was only called upon once, and that was January the 2nd of 2019. And she prepared one report, which the plaintiff's MFM has no criticism of, as indicated in the papers and as indicated in the record. The plaintiff's reply to this is based upon a supposition that if Dr. Murphy had been called, she would have done something different. That supposition is not supported in the record. She didn't know about any follow-up. Mrs. Jones did not reappear for the scheduled appointments that Dr. Murphy had twice set. And no one informed Dr. Murphy of any follow-up. So the plaintiffs have not created a genuine issue of fact as to Dr. Murphy, either on standard of care or on proximate cause. Their reply brief sets up a contingent situation. They say, well, if she knew this, then she would have done that. And I think that the pages 164 and 165 of Skinner give the court adequate direction with regard to contingent testimony. Specifically, the last paragraph on 164 and the top paragraph on 165. I won't read it to the court unless the court wants me to, but those paragraphs basically say that you cannot, it is not sufficient to submit a causation theory that is not factually supported and remains a theory. In other words, mere allegations are not enough to defeat a motion for summary judgment. That's all I have to say about Dr. Murphy's motion and their reply.
All right, thank you. And as in past hearings, Ms. Walsh or Ms. Sikorsky, I don't mind if each of you are taking different motions, but I'll just ask that one of you argues each motion, however you want to proceed.
Understood, Judge. I will be handling this one. So Dr. Murphy was consulted twice in this case. She was consulted on December 31st when there was an abnormal Doppler study. And then this patient presented to Dr. Murphy's office on January 2nd for an ultrasound and a Doppler study. Notably, Cheyenne was supposed to return back to Dr. Murphy's office for another ultrasound on January 23rd. At that time, there was a snowstorm. Dr. Murphy told her, don't worry about it. She didn't want her having to try and make it there. And Dr. Murphy at that time had made the determination that no further MFM follow-up was needed, but she wanted her to have a growth ultrasound. This was communicated to Dr. Kiley. Dr. Murphy never inquired about the prenatal testing that had been ongoing that she was aware of, considering this diagnosis of IUGR. Dr. Landon had testified that she should have been aware of that. She should have asked, somebody should have advised her of that information. If not, Dr. Murphy had a duty to ask that. So it's defense wants to focus on her not knowing the results of the ultrasound on February 4th, but it's more than that. Had she inquired when she made the decision that no further MFM follow-up was required on January 23rd, she would have learned that this patient had an ultrasound that showed the estimated fetal weight in the first percentile and another abnormal Doppler at that time, which would have required a plan to be put in place to deliver this baby. This baby should have been delivered at 37.6 weeks, but definitely no later than the 39-week gestation. So there is a genuine issue of material fact that does exist as to Dr. Murphy's negligence in this case, and it's not just limited to whether or not she had any information as to what showed on the February 4th ultrasound.
May I respond briefly, Your Honor?
Yes.
What plaintiff's counsel just said, if Dr. Murphy had been informed of the January 9th ultrasound, she would have ordered something different. That's not supported in evidence. And it assumes that if Dr. Murphy had reviewed that film, she would have found it to be abnormal. And I submit to the court that that's not the case. And the plaintiffs have no evidence to suggest that that is the case, because they have not asked her what the film actually shows.
Okay, thank you. Ms. Sikorsky, anything further from your side on that?
Well, Dr. Murphy was relying on the information that she was getting from Otsego. So on January 23rd, when she made that, first of all, when the patient was there initially on January 2nd, she should have made a plan going forward as to the standing IUGR diagnosis that was there. That if this patient has another abnormal Doppler, if this patient has another estimated fetal weight that's below the 10th percentile, the plan should be to deliver her by X date. That was never done. Once January 23rd comes around, then it's her obligation to inquire about as to what the prior testing showed. And at that time, make a delivery plan. And then again, we have one more chance on February 4th when the patient is there for an ultrasound that again shows that this patient is IUGR and nothing is done. There's no plan set by Dr. Murphy at all in her involvement in this patient's care, which actually spanned from December 31st up through arguably February 4th, because she was supposed to be copied on that ultrasound study.
Okay, all right, thank you. Ms. Greenman, did you have any input on this motion?
Yeah, the only input, Your Honor, that I will remind the court is, plaintiff has also relied in their argument, as well as their expert, Dr. Landon, thinking that Dr. Murphy worked for my client hospital. She did not. She worked for Munson, not Otsego, and she did not have access to anything Otsego. I just want to make sure that that was clarified for the record.
Okay. All right. Again, I did have a chance to review the briefs. I reviewed as part of this motion, Dr. Landon's deposition. I also reviewed, although I had done that as part of the other motions, reviewed Dr. Okor's deposition as well, and Dr. Murphy's deposition. This is a motion for summary disposition. Defendants have brought it pursuant to C8 and C10. I really view this more as a C10 motion. I think that plaintiffs have stated a claim here. I don't think this is really a C8 issue. The court's really looking at this as to whether or not there is a question of material fact, genuine issue of material fact with regard to both a violation of the standard of care and proximate cause. All the parties have properly cited the court rule and the case law applying to motions for summary disposition under C10. Primarily, the court has to view all the evidence in the light most favorable to the non-moving party, which is the plaintiff in this case. And in order to grant the motion for summary disposition, again, the court would have to find that no reasonable jury could find Dr. Murphy liable, again, based on the fact that plaintiffs have not created an issue with regard to the standard of care and causation. In looking at the underlying facts here and what evidence is there that plaintiff has brought forward to create an issue, the first thing I guess I looked at or I thought was important is just kind of the general reason why Dr. Murphy was brought into this case, and that's because Dr. Murphy is a maternal fetal medicine specialist, and she was brought in to consult by Doctors Kiley and Miner to help them understand and properly treat the plaintiff and her unborn child because of this difficult pregnancy. And I think the timeline that's set forth in the plaintiff's complaint and reiterated in the defendant's brief pretty firmly establishes this was a very difficult pregnancy throughout. And I think it was reasonable for Dr. Kiley and Dr. Miner to seek consultation with the doctor specialist. And I think looking at the whole reason why Dr. Murphy here is involved, and the whole point of her involvement is to help Dr. Kiley and Dr. Miner figure out how to properly treat the patient. And I think that's apparent from the circumstances, but I'd also point to pages 83 and 85 of Dr. Landon's testimony, where I think brings that out, the purpose of her involvement. Dr. Landon gives his opinion about where the standard of care was breached, and his criticisms of Dr. Murphy wasn't necessarily her follow-up letter that she prepared and sent to Dr. Kiley after the visit in early January 2nd. It's that Dr. Murphy failed to establish a delivery plan and failed to verify the due date, which would have affected all the dates going forward in terms of when this baby should be delivered if all the tests continue to be or showed some abnormalities that would require an earlier delivery. And that comes from pages 14 and 15 of his deposition. He further discusses that later on about page 82. And then page 17 of his deposition, he's also critical of the failure of Dr. Murphy to, again, establish a birth plan or delivery plan on January 23rd. Dr. Landon does admit that based on the information that Dr. Murphy had on that January 2nd visit, there would have been no reason to recommend a delivery before 39 weeks, and that's at page 18 of his deposition. But I think where the issue comes in is what happened after that. And I think based on the testimony of Dr. Landon, what his problem with Dr. Murphy and his findings as to where she violated the standard of care is whether or not she was aware of the abnormal testing on January 9th. What she should have done was to say, okay, if the tests come back as A, then you need to deliver at B. If the tests come back with C results, then you need to deliver at D. In other words, a multifaceted plan where Dr. Kiley and Dr. Miner could have looked at test results like the Doppler, like the other tests that they were doing, and said, okay, this is trending in the direction of what Dr. Murphy recommended under Plan A, or this is trending in the direction of what Dr. Murphy recommended under B. And that's the whole reason why Dr. Murphy was brought in, to help Dr. Miner and Kiley understand the results they were seeing and what that meant in terms of when they needed to deliver this baby. And so the failure, according to Dr. Landon here, is Dr. Murphy's failure to do that, which was the whole reason why she was involved in the case. And then, of course, the failure to verify the correct due date, which again would have affected the direction that that plan went in. In my view, that Dr. Bocor's opinion about when the baby should have been delivered doesn't really affect Dr. Murphy's liability here. Again, Dr. Landon's criticism isn't her decision or her opinion to have the delivery on the 4th. It's the lack of the plan and the lack of the verification of the delivery date where the issue is. And I think through Dr. Landon's testimony, it's also clear in terms of causation that had Dr. Murphy appropriately provided that plan to Drs. Kiley and Miner, and they had followed that plan, then it would have resulted in an earlier delivery, which would have avoided the injuries to Peyton. So again, looking at this under a standard of a motion for summary disposition, a jury may view it differently, but this is a motion for summary disposition. It's a low standard. The court has to view the evidence in the light most favorable to the plaintiff. And so for all the reasons I've stated and based on the evidence, I think I referred to all of the last point I made I'm referring to pages 71 and 72 of Dr. Landon's deposition. But based on that evidence, the court finds that there is sufficient question on these issues with regard to Dr. Murphy, such that summary disposition is not appropriate. And so the court will deny the defendant's motion as to Dr. Murphy. The next motion for summary disposition is with regard to Dr. Janette. And so Mr. Valatutti, if you'd like to present your argument on that motion.
Thank you, Your Honor. Dr. Janette is at the time of his deposition and at all times pertinent thereafter, retired OBGYN. He had one involvement in the case, and that was at 35 weeks. The plaintiff came in, not the plaintiff, but Cheyenne Jones came in complaining of what she thought was preterm labor. And so he evaluated her on a couple of times around, I think the 9th, 10th, and 11th. The allegation against him is that he should have communicated to the MFM. The MFM in this case is Dr. Murphy. And so they also say, well, he should have communicated to doctors Kiley and Minor, the abnormal report of January 9th. And that if he had done that, then something different would have occurred. What exactly different would have occurred is not known. Again, the January 9th report, if given to Dr. Murphy to review, would not have been the report she would have relied on. She didn't rely upon the December 31st report and found it to be materially wrong. You'll remember from the facts as you read them that on December 31st of 2018, that report suggested that this baby was at the 4th percentile. Dr. Murphy, doing her own film, found the baby was at the 27th percentile. The December 31st film showed, was read by Otsego radiologists, who are really not obstetrical specialists, as showing abnormal Dopplers. Dr. Murphy's film did not show abnormal Dopplers. So no one was relying upon the Otsego radiology department after that, because they were not only a little wrong, they were substantially wrong. And so the plaintiffs have a gap between this idea that Dr. Janette's reporting to either Kiley or Minor or Murphy would have resulted in a different result. Neither Kiley nor Murphy nor Minor testified that they would have done anything different. And the plaintiff's expert against Dr. Janette says that that is Dr. Bokar, he doesn't have any, doesn't believe that anything done or not done by Dr. Janette, as you are well aware, having read the papers, was done wrong. The only thing against him is this allegation that if he would have told Murphy or Kiley or Minor about the January 9th report, that different actions would have occurred. But that there's still 3 other possibilities as to what would have occurred. Dr. Murphy would have been well within the standard of care to look at the film and see whether or not it was in fact irregular. She would have been required as such because she was already on notice from the prior reading of January 2nd that the radiology department was an unreliable quantifier of obstetrical ultrasounds. And the same is true of Minor and Kiley. When they received the report from Dr. Murphy that, no, the baby's not growth restricted, the baby's in the 27th percentile, well above the 10th percentile, and has normal Dopplers, they weren't really relying upon the ultrasound reports of Otsego. The Otsego reports are what they are. And they are the foundation of the plaintiff's case. But when you call in a consultant You expect that consultant to review those films. This is not uncommon, by the way. Radiologists are not sophisticated in reading obstetrical ultrasounds. In the December 31st reading, or I believe, we'll be able to show that the calipers were put on the wrong places. So they're recognizing the wrong object as the baby's size in quantifying growth. And after that, no one's going to rely upon them. So the plaintiff had the opportunity to take the depositions of Kylie, Minor, and Murphy, and never asked them what different actions they would have taken had they been contacted. And they have never established they would have taken the action which they alleged they should have been taken. So there's no testimony regarding that satisfies the but-for rule set forth in Skinner. You can't supply that by expert testimony. You can't supply the but-for testimony by an expert saying, well, the other person should have done this, when in fact the other person gets to explain whether or not they would have done that, and why they would or would not have done what the plaintiff assumes they should have done, and the plaintiff's expert assumes what they should have done. And so I think Dr. Janette is entitled to a summary judgment because no one testified they would have changed their conduct based upon anything he would have said to them. They don't have any evidence of that. Again, they're using a leading question to Dr. Landon as the basis of their case against Dr. Janette, that, well, Murphy or somebody should have or would have done differently. Well, that's not established in the record, and it has to be a fact established in the record, not mere opinion with regard to what happened. They don't have but-for testimony, and it's a fatal defect in the case that is persistent with regard to both Murphy and Janette. And I thank the court for allowing me to speak on the matter.
Thank you. Ms. Sikorsky or Ms. Walsh?
Yes, Your Honor. So Dr. Janette was involved twice in this case, first on January 9th when he was the doctor covering the unit when Cheyenne came in for her prenatal testing. She had a Doppler done that day. That Doppler was abnormal. He did not communicate that to Dr. Murphy. He didn't communicate that to any of the providers at OMH. Cheyenne then presented the next day on January 10th with complaints. Dr. Janette's diagnosis at that time was IUGR, and then his plan was to monitor, admit, and deliver. And he himself testified on that day that he would not make any determination as to delivery in the context of IUGR, that he himself would have to consult MFM in order to determine when a patient should be delivered or if she should be delivered given the context of IUGR. So given his own plan, he didn't consult MFM. Their expert defendant Thiel testified that communication should have been given to Dr. Murphy regarding these abnormal test results. It's interesting, given Mr. Velatuti's argument that, and I think it becomes even more important that Dr. Janette didn't communicate this information to Dr. Murphy. If Dr. Murphy had no intention of relying on the information that was being presented and the testing being done by Otsego, it would make it even more important that Dr. Janette communicate this abnormal Doppler finding that had been performed on January 9th. If in fact Dr. Murphy wanted to review that independently on her own, which did not happen. And I would say that Dr. Murphy was not, it would be interesting to say that they weren't relying on the testing that was being done by Otsego, considering they still continued to do testing on this patient. This patient continued to have an IUGR diagnosis. Although the Doppler was normal that Dr. Murphy performed on January 2nd, she said in her report that she was concerned that that was a transient finding based on the steroids that Cheyenne had been administered. had been administered at her appointment, meaning that she did have concern that that Doppler that had been done on the 31st was abnormal, and her normal finding of the Doppler on January 2nd could be a transient finding because of the medication. Then we see after that she has an abnormal Doppler on January 9th. And what it was is Dr. Janette's failure not to advise anybody of this information. Dr. Kiley and Dr. Miner, if you look at the OMH record where they have the history of all of the test results, and if you look at Dr. Miner's history, he makes no mention of any of the test results after the ultrasound showing that the fetus was at the 4th percentile. So appears to know nothing about the abnormal Doppler that was done on January 9th, nothing about the ultrasound that was done on the 18th showing the fetus at the 1st percentile, and then nothing on the 4th. So nobody has any idea about what is going on with this testing that they ordered. They order the testing because of this diagnosis of IUGR, which they all know what the effects of that can be, that the baby can end up with a lack of oxygen to the brain or dead because of this. And then everybody ignores the testing. And here, Dr. Janette had not one but 2 opportunities to advise both Dr. Murphy and OMH to ensure that there was a plan for this patient, what the plan should be, and make sure that everybody knew. Now here she's coming in, she had an abnormal Doppler on 12/31, which was a critical abnormal Doppler. And here she is back on January 9th. And again, we still have an abnormal Doppler. But again, nothing. And we know that this baby was neurologically intact up through February 4th, which we know that because she had a reactive non-stress test on that day. So at any time, had Dr. Janette provided this information to the treating doctors or Dr. Murphy, then it should have been, okay, we need to get this baby delivered. We have an IUGR baby, we have abnormal Dopplers, and per the standard, we have to get the baby delivered by this date. That wasn't done in this case. And a genuine issue of material fact exists that had Dr. Janette done that and communicated this information, and the people who were caring for this patient had been aware of that, then they would have scheduled Cheyenne for earlier delivery, and Peyton would have been delivered not brain injured.
Thank you. Mr. Valatutti?
Just a brief response. What Consul just said, had they been aware, they would have scheduled for delivery. There's no testimony to support that. That's their allegation. Had they been aware, had they been, and I have to, and it would be important to understand that what the Otsego radiologist reported is in the record. And Kiley and Miner are charged with the knowledge of that. And it's very important to understand that the consult with Dr. Murphy, had it been requested, as the plaintiff's experts say it should have been, it's very important to understand what she would have done had she been consulted on those dates and seen those films, and they don't have that established. And so they can't establish proximate cause with a mere allegation. That's all I have to say on Dr. Janette's behalf.
It's if I could, Your Honor, just quickly.
Yes, you can, but let me just see if Ms. Greenman has anything to add so that you can respond to both if she does.
Yes, thank you, Your Honor. Only thing that I would like to echo with Mr. Valatuti's arguments, I believe it was on page 14 of our motion. That's really, everything else has been a little bit distracting. The issue is Dr. Boker, their expert, page 25 of the deposition, Mr. Valatutti asked, was Cheyenne or the baby in any way injured by anything done or not done by Dr. Janette? Answer is no. It does not meet the burden under Standard Jury Instruction 30.03.
Okay, thank you. Ms. Sikorsky?
So going back just to address the causation that Mr. Valatutti has brought up. So ACOG specifically states what you do when you have an IUGR baby and what you do when there are abnormal Doppler results. All the defendants in the case are aware of that. They agree that that would be the standard of care given the test results. Dr. Boker, when he was asked that question, did say no. Now, was there anything that Dr. Janette did specifically on January 9th that caused any injury to baby Peyton on January 9th? No, there wasn't. Was there anything specifically that Dr. Janette did on the 10th or 11th that caused injury to baby Peyton on the 10th or the 11th? No, it wasn't. It was his lack of not following up and informing the people who needed to know that information of these abnormal test results that would have and should have resulted in this baby being delivered earlier. So that is where the issue lies with Dr. Janette.
Okay, thank you. So again, this is a motion pursuant to C10. I've already stated the standard for that, and so I will continue to rely on that in terms of motion ruling on this motion. Again, I started looking at this from the larger general view of what the plaintiff's claim here is in this case, and I think generally it's that this baby should have been delivered earlier, and had Peyton been delivered earlier, she wouldn't have suffered the deficits that she ended up suffering. So I've got to look at Dr. Janette's involvement in light of that general statement of, I think, the overall claims of the plaintiff here. And I did review Dr. Bokor's deposition in this case. Counsel's referred to a couple pages that I do think are pertinent. I'm not going to cite to specific pages of his testimony. I'm citing generally to his testimony in terms of what I find it to be lacking in. But Dr. Bokor is clear that his criticism with regard to the standard of care was that Dr. Janette should have informed the maternal fetal medicine doctor of the abnormal tests, and that he did not. And that may or may not be a violation of the standard of care. I think that's less important to this motion than the causation issue. And I think in order to deny the motion here, the court has to find that there's a question of fact as to whether anything that Dr. Janette did or didn't do with regard to informing the MFM or anybody else of the abnormal test, whether his acts or omissions are connected to late delivery or the alleged late delivery of Peyton in this case. And when I look at the testimony of Dr. Bokor, what I find it to be lacking is any specific testimony by Dr. Bokor to connect any acts or omissions of Dr. Janette to the actual late delivery, which then resulted in injuries. I was unable to find anything in the testimony that linked Dr. Janette's failure, if it was a failure to inform the MFM or anybody else, to an actual later delivery date in this case. There certainly isn't any testimony that Dr. Janette should have ordered the delivery at the time on the 9th and 10th when he saw Cheyenne. And there isn't any testimony that would connect the failure to communicate the testing to the MFM, that actually led to a later delivery date or caused the delivery, or if something or if he had communicated it, that it would have resulted in an earlier delivery date. So I agree with Mr. Valatutti here. Plaintiffs certainly make a logical argument, but there isn't any actual evidence to support that argument. And in order to deny the motion for summary disposition, the court would have to be able to rely on some kind of evidence, not just a logical argument. So I find that there is not sufficient evidence on the issue of causation with regard to Dr. Janette, such that there's a genuine issue of material fact that his failure to communicate with the MFM either led to a later delivery date or would have resulted in an earlier delivery date. So for those reasons, the court will grant the motion, and Dr. Janette is entitled to summary disposition.
Thank you, Your Honor.
So that concludes those two initial motions. I just got a note, I got to deal with something unrelated to this case really quickly. It'll take less than 5 minutes. So I'm just gonna put things on hold here for just a second, and I'll be right back on the record. You can all remain connected. Okay, council, I'm ready to resume, if everybody's there.
I'm ready, Your Honor.
Okay, great. Again, thank you. Appreciate your patience during that interruption. Okay, so the next motion that I have is plaintiff's motion. This is with regard to excluding defense experts, Dr. Curtin, and not sure how to pronounce that name.
Yom.
Yom, okay, and Dr. Yom. So Ms. Walsh or Ms. Sikorsky, if you'd like to proceed with argument on that motion.
I will, Your Honor. And I will try to just be very brief and address the arguments of the defendants. Although there is a couple of, I think I have to dovetail into my briefs shortly. So Dr. Yom and Dr. Curtin have espoused a causation theory in this case that is completely unique to the two of them. None of the other defense experts, none of the plaintiff's experts, none of the treating doctors anywhere have agreed with this theory. And in fact, as I will point out, Dr. Curtin actually in his own writings dispels that this causation theory could be the case. The evidence, so first of all, Dr. Curtin has written a book chapter on PAIS, which is the claimed theory is that this baby had a very specific type of a stroke that was caused by an embolic shower. So there has to be a source for the emboli. And when you have an embolic shower, that means you shoot emboli to all over various places. So various places in the brain, the heart, the lungs, the other organs of the body. So in order to have an embolic shower, number one, there has to be a source. You would see emboli in various parts of the body. And with that as the basic knowledge of this, Dr. Curtin admits what the clinical criteria, because he's not a radiologist, so he admits what the clinical criteria is for PAIS, and Peyton Jones did not fit into his criteria. And in fact, using his criteria, one would not diagnose PAIS because the baby's symptoms did not match, were not even close to clinically matching what he says in his text chapter would be the signs and symptoms of PAIS. Both of these experts, although they acknowledge there was an both of them, although they say there was an embolic shower, they both admit that there was no evidence of any embolus anywhere in the body, including in the brain. An MRA of the brain was done to specifically check the vasculature of the brain, and it's called an MRA MRV. So checks the arteries and the veins. Not one embolus was found anywhere in the brain to support that there was one or more emboli there. Dr. Curtin hypothesizes that it came from the placenta, but both the placenta and the umbilical cord were completely normal and free from any type of emboli or any type of thrombus that would have thrown anything. So there was no evidence that no other organ in the body had any evidence that it had been affected by an embolic shower or that it was the source of a shower, because the normal place for an embolic shower in an already born human would be in the heart. And there's no evidence of any heart or any other body organ that had any source for an embolic shower. So we now have no source. We also have no emboli anywhere. And PAIS does not meet the criteria that Dr. Curtin himself said you should have. This really, Your Honor, goes to mostly MRE 702. And there's no evidence to match their theory, which we addressed in our brief. The defendants in their brief go on at length about the Figursky case, which is a known and diagnosed PAIS case in that particular situation. The Figursky case was a question of whether there was, in addition to PAIS, also an asphyxial event to the baby that it caused additional damage to the PAIS. That's what that whole Daubert hearing was about. And in fact, I believe in the Court of Appeals, it was reversed to the the trial court for a further hearing on that issue. But the fact of the matter was, in that case, it wasn't a question of whether there was PAIS. This theory is not accepted by, obviously by Dr. Curtin, or anybody who reads Dr. Curtin's literature would say this patient did not have PAIS because it didn't meet the clinical picture. In terms of the Daubert standard and looking at, I'm just going to address a few aspects of it. Number one, other doctors in regular practice would not accept this because they would follow Dr. Curtin's textbook, certainly, before they would follow what he said in this case. And furthermore, the other aspect of it that I think is very important is, do the other experts in this case agree with it? And the answer is no. The other defense experts don't even agree with this. In fact, they're the only two that have this unique theory that doesn't fit the facts of our case at all and isn't supported by any of the other experts in this case, nor would it be agreed upon or accepted by general practitioners who would certainly look to Dr. Curtin's textbook before they would look to his testimony in this lawsuit. Unless the court has any questions, that's all I have.
No, thank you, Mr. Valentucci.
Your Honor, do you have the ability to share screen? I can show you in
Yes.
a picture what would take me a lot of words to say.
Okay, I can do screen sharing. Let's see.
So if I hit on share,
Yeah, I think I have to enable it, so give me a second here. Okay, it should allow you to share now. Oops, hold on a second. Nope. Okay, now you should be able to.
okay, so this is what I want to show. Let's see if it shows. Can you see this picture?
Yes.
All right, this is given to me by Dr. Curtin just a few days ago. And this shows why the placenta doesn't show emboli. And that's the only part of the baby's body. And the placenta is part of the baby's body. That's the only part of the baby's body that was examined. And when you send the placenta down to the lab, they make slides of various portions. They don't do the entire placenta. So what this shows is that if you have a thromboembolism in a placenta in the smallest areas of the placenta that are not captured in the slide, then you don't get a specimen of the emboli. There's no scientific literature that says there's a 100% requirement that you find the emboli in the placenta. In fact, a large portion of cases do not find emboli in the placenta for the very reason is depicted by this picture. Secondly, the plaintiff's motion in this case is not supported by the affidavit of any expert, nor the testimony outlined of any expert that disagrees. And what I found particularly interesting, and I didn't really understand this until I read it over the second time, is that they didn't even put into the court's hands the deposition of Dr. Zay, their pediatric neuroradiologist. And if I may change this image to Dr. Zay's testimony on page 41. Can the court see this?
Not yet. All I can see is your computer's desktop.
You're just looking at the desktop. Okay, why isn't it showing? Now? Well, I'll have to send this page, but I had assumed that they would have sent the depositions of Dr. Zay to you because they're contesting the opinions of Dr. Yom and Dr. Curtin. Dr. Curtin reads MRIs himself. So let me just read to you what Dr. Zay says on page 41 of his dep. I don't know why I can't get this to show, but I can't. Let me see. If I close this out and return your screen sharing. No, it doesn't. Oh, I see. Does it? Can you see it now?
Yes, we can see it.
Oh, okay. So this was the Dr. Zay's testimony from page 41. So it's your opinion that this February 9, 2019 MRI is not suggestive of a stroke? Answer, not suggestive of a focal stroke. That is correct. You'd have to say there are at least 1, 2, 3, 4, 5, 6, 7, or 8 little strokes. That's exactly what our experts have said. And then, so this would be what, about like embolic mini little strokes? These findings would be consistent? And Dr. Zay admits it's possible, it's just unlikely. Basically, strokes usually go to areas where there's a lot of blood flow. And that's if they're large, but if they're small, they don't. And so some of these are not typical areas of embolic strokes, although nothing can be ruled out. Their expert witness can't rule out stroke. They want the court to rule it out based upon the allegations of plaintiff's counsel that are unsupported by affidavit, testimony from Dr. Curtin, who they had a complete opportunity to cross-examine regarding his own text, and he doesn't agree that his finding of multiple strokes in this case is unscientific or is contradicted by anything he said. And if they're going to impeach him in front of a jury with regard to the textbook, they're certainly allowed to do that. And I would encourage them to do that and see what the doctor says if they do confront him with his own textbook. In short, Your Honor, this is an inappropriate motion for a Daubert challenge. The scientific phenomena of neonatal stroke is something that has only been picked up by textbooks since 2018. But now it's well known because the neuroradiological equipment that the doctors have is much better than they had before. So when Dr. Glass, I think it is, yes, it's Dr. Glass, when he received his training, and he's older than I am, which makes his training very old. They didn't have the ability to see strokes. The interesting thing is that both Dr. Yom and Dr. Curtin, when they reviewed the films independently without knowing each other's findings, said these are strokes. And the other thing the plaintiff said is it's not true, is that it's not testified to by others. Well, it's in the records, the medical records of Peyton. If the court can see this, this is from the Munson records that were produced in this case. And I'm reading here from the page 3 of the record as produced. And here it says, oh, if I can see it. Okay, here it is. I can't highlight this, but it says this distribution on the left suggested middle cerebral artery infarct, as opposed to watershed distribution seen on the right. And it says it again in another page on the record. The distribution on the left suggested middle cerebral artery infarct as opposed to watershed distribution on the right. That's what we're saying. And because this is a fact of the case, and the defendant's testimony is not only based on fact, but based on MRI film and the sequelae. The sequelae of this is that when you have these mini strokes to the to the area of the brain that Peyton has mini strokes in, language is one of the abilities that is compromised. And that's all I have to say about this. It would be, I think, incorrect to preclude a pediatric neurologist who sees the emboli on the film and the pediatric neurologist who also sees it on the film and also correlates the clinical findings. To preclude them from testifying would be, I think, inviting error into a case, especially given Judge Gleischer's admonition to the court. And if you read the Figursky case, you know that they relied heavily on Court of Appeals Judge Lisa Gleischer. And in one of the few instances in which I've seen a Court of Appeals a decision rely on an unpublished opinion, they did in this case because I think they had some respect for Judge Gleischer's prior involvement. She was well known and is well known as a significant lawyer who not only has knowledge of the perinatal injury matters, but worked in the Goodman law firm, a well-respected law firm, before starting her own law firm and before going on to the Court of Appeals. And she said, look, the trial courts are not supposed to decide issues of science. They're just supposed to determine whether there is one based upon the evidence. And based upon the evidence, we have MRI evidence of stroke. We have clinical correlation. We have the world's leading authority on stroke. And both of whom are involved in academia and are teaching residents within their own science. They are well respected by pediatric neurologists and pediatric neuroradiologists. And their own pediatric neuroradiologist agrees this could be stroke. That's all I have to say.
All right, okay, thank you. And can you close that
Yes, I will.
sharing? Okay, great, thank you. Ms. Greenman, anything that you needed to add?
No, Your Honor, I echo Mr. Valetuti's arguments in response.
Okay, Ms. Walsh?
Yes, I'd like to, I first would like to ask the court to please rely upon the evidence and not on Mr. Valetuti's statements. I'm going to try to respond to a few of them, but most of what he said has not been testified to by an expert. First of all, the world's leading expert, if there is one, on reviewing all head imaging is our expert, Dr. Zay. I don't know who he was referring to even as the world's leading authority in stroke, because I'm not aware of any expert in this case that meets that criteria. Second, as to the placenta, Dr. Curtin himself in his testimony said he saw no evidence of any type of an embolus or thromboembolus or thrombus in the placenta. The placenta is cut and there are representative sections of it taken and reviewed. You can't speculate that maybe in some small area that they missed, there would be an embolus. I mean, that's not allowed in the loss. That is pure speculation that perhaps in their representative sampling, they missed it. So based upon what Dr. Curtin testified to and what the other experts have testified to and what the records say, the placenta was normal. That's the only fact we have. That's the only thing that can be relied upon in this case. Dr. Curtin testified, and I believe it was in our brief, he was asked, with PAIS, this baby appears to be completely normal until at least the day after the injury, which is when you would start to see the baby decompensate. And he said, yes, that is the classic clinical picture for PAIS. And then he went on to say, this baby was depressed at birth and did not meet the clinical picture for PAIS. That's what the testimony in this case is in that regard. Second, I guess the next thing I want to say is a mid-cerebral artery stroke is a very specific type of a stroke that occurs in one place and only one place in the brain, and that's in the mid-cerebral artery. So this PAIS, which is a whole bunch of tiny little strokes, is not what they reported in the MRI. And I would ask that the court, if necessary, review what the witnesses have said. This is not PAIS, what Mr. Valatutti just pointed out. If you had a mid-cerebral artery stroke, I would put that on the screen and show you, and every one of us would be able to identify that on an MRI because it's in a very specific spot and it's going to be a big blob. That's what a mid-cerebral artery is. It has nothing to do with what they're claiming. And I want to make sure that the court saw, although I know Mr. Valatutti did have it on the screen at the bottom, Dr. Zay said, who is Yale trained, he's a Yale doctor, all he does, 50% of his time is looking at neonatal head imaging. And he said, it's unlikely that this is mini strokes because it just doesn't happen that way where you have this global diffuse injury. And what he said, and the reason I didn't attach any of my experts, because my experts had all been deposed, we didn't know about this PAIS theory. So our experts didn't specifically say, here's all the evidence why it's not that. But Dr. Zay's opinion and all of our experts' opinions, this is a classic case of birth asphyxia at birth. And you saw in the report that Mr. Valatutti put up, it talked about the fetal bradycardia, meaning the baby's heart rate dropped for an extended period of time before birth. In terms of this being a Daubert hearing, I think I mentioned at the outset, this is more of a 702 argument, I believe, because they didn't apply the facts of this case to their argument. I mean, we're not saying that PAIS doesn't exist out there in some case. It does not exist in this case, though. So it's more a failure to apply the facts to this case. You could also use that in the Daubert hearing in the several areas of it where it asks, is this an opinion that's general population of physicians would agree with in this case? And the answer to that is no, and nobody has stated that's what this was ever. And none of the other experts in this case agree. So to the extent that it applies to Daubert, it bodes against them because the facts that would be pertinent in terms of other doctors in the profession and in this case, none of them agree with this. Thank you.
Okay. All right, thank you. Again, I did review the transcripts of both Dr. Curtin
Yom.
and Dr. Yom. I read through both of their transcripts along with all the other information that was provided with the briefs. I think the parties accurately cited the standard for admissibility of expert testimony, both under 702, 703, and the statutory complication of 629.55. And the court would adopt the standards as articulated by the parties in terms of admissibility of this kind of testimony. I think, again, stepping back and looking at this from a big picture standpoint, the court in these types of motions is tasked with the role of being the gatekeeper, not the trier of fact. So the court isn't making ultimate decisions and ruling on this kind of motion about which experts are right, which experts have the better opinion, or whether which expert the jury should accept. The court is only deciding whether the expert's opinion is sound enough that a reasonable jury could be aided by it. In other words, it would help the jury to understand the case, and that it is reliable enough that a jury could use it in deciding the facts of the case. And so I think it's important, again, to look at the role of the court here, just as I indicated with regard to motions for summary disposition. The court is just a gatekeeper so that the information that the jury gets is reasonably reliable. I think sometimes parties ask the court to go beyond that gatekeeper function and make ultimate decisions about quality or ultimate correctness or accuracy of an expert's opinion, how convincing it is. And I feel like that's what's going on with this motion, and frankly, some of the other motions as well, because, you know, this is I think the arguments of counsel here on the record kind of are, demonstrate that, because I think what we really have here are competing experts' opinion that are both rooted in the underlying facts of the case. There's certainly differing opinions, but that doesn't mean that they're not admissible as expert opinions. In my view, reading through the depositions, I think both Dr. Young and Dr. Curtin offered plenty of factual support for their opinions that these were strokes and not HIE or something else. Based on the evidence, it's clear to me that they aren't just off the cuff coming up with these theories, and that they're relying on what they reviewed and the evidence in the case. And with regard to Dr. Young, I specifically point to testimony on pages 37, 38, 43, 44, page 59, page 66 of that deposition, where Dr. Young indicates that, after review of the imaging that was done both immediately after Peyton's birth and later on in September of 2019, that what that doctor's viewing on that imaging is evidence of embolic strokes. And while pages 43 and 44, Dr. Young can't say the exact source of it, Dr. Young was pretty clear that based on what she saw on the imaging, which in her opinion, looking at page 59, wouldn't be able to necessarily see the clots or clotting on the imaging, but you would be able to see the damaged tissue that was caused by the stroke. And it's her view that what she is viewing are lesions that would have resulted from an embolic stroke, not from some other type of cause. Looking at Dr. Curtin's testimony, pages 39 and 40, and based on the neuroimaging, it's Dr. Curtin's opinion that it was a stroke. Dr. Curtin indicates that sometimes the testing can't say whether or not it was a stroke, but it can't really say whether or not it would have been HIE either. With regard to the debate over the source of the emboli, looking at page 60 of Dr. Curtin's deposition, where he opines that it's likely the placenta would be where the emboli came from. He's not just basing that on conjecture either, although I think the doctor concedes that there isn't any imaging that shows or any other testing that shows definitively that it came from the placenta. It's Dr. Curtin's opinion that looking at all the other evidence from the imaging indicates that it is a stroke, an embolic stroke. And so if everything else points to embolic stroke, then looking for the cause, it's kind of a process of elimination. And it didn't find any evidence that it's from a cardiac source. And so in Dr. Curtin's opinion, if everything else is showing embolic stroke, then you've got to try to go through a process of elimination. That's what I took from his testimony. And what that leaves, in his view, most likely in this case, which he testified to, is the placenta as the source. Now, other experts may disagree with that. It may be subject for cross-examination, but it doesn't mean that Dr. Curtin is, again, pulling that opinion out of thin air and basing it on the facts that are specific to this case, the testing that was done, and his knowledge of that. So, again, for all those reasons, the court finds that while there may be differing opinions by plaintiffs' experts, the jury is ultimately going to have to decide which opinion they find more convincing and more believable based on all the other evidence. But again, under the gatekeeper role, the court can't say that Dr. Jones and Dr. Curtin's opinions are not based on evidence in the case and aren't otherwise reliable. So the court will deny the motion to exclude those two witnesses as experts. The next one that I have is defendant's motion, and the next two, I think, that we're gonna address are the expert opinions on Dr. Huckfeld and also Dr. Houseworth. So first of all, defendants have the motion against it. It's plaintiff's expert, Dr. Huckfeld, Mr. Valtutti. That's to that.
Thank you, Your Honor. Just indulge me for a moment. I guessed wrong with regard to the next motion. So let me see if I can find it. Well, I can, here it is. Okay.
These two are kind of, in my view,
Yeah.
and we'll deal with them separately, but they kind of go hand in hand.
Right.
So go ahead, Mr. Valtutti.
So Dr. Huckfeld is a medical doctor, but he's not testifying as a medical doctor in this case, and I think it's important because he's not in rehabilitation medicine. He's not involved in pediatric neurology, neuropsychiatry. He's been disabled from his chosen profession as a trauma surgeon because of latex. I think it was latex sensitivity or some sensitivity. Anyway, so he went to school as a life care planner, and I've laid out in my brief extensively that life care planners really don't exist in the real world for any purpose other than the purpose of providing lawyers with testimony regarding future care costs. And this is borne out by the progenitor of all life care planners, who is Paul Deutsch. And I laid out in the papers that, life care planners were a profession created by lawyers for lawyers. In fact, there's a lawyer acting as a life care planner, Dr. Foreman, who is both a doctor and a lawyer, or maybe he's a psychologist and a lawyer. But in any event, life care planners, they go to conventions and they discuss in their conventions how to avoid Daubert hearings, because they go to a lot of them. And the reason that they do is because from time to time, as is shown in the papers that I filed attached to Dr. Huckfeld's report, courts strike him for using improper sources. Now, experts generally are allowed to rely on hearsay sources, but the hearsay itself must be admissible. So the hearsay source that Dr. Huckfeld relies on for his pricing, the subject matter of his testimony, the way that he intends to assist the jury in deciding an issue in this case, is to give them knowledge regarding the future care cost of Peyton Jones. So how does he do that? Well, he uses a privately published source. This is not a public source, not a government publication. It's, I think he uses the Physician Desk reference, or he uses Fair Health. These are two competing companies. I don't remember which one he used, but he used one of these services, and I think I have the service here. They're very expensive books to buy, not the kind of thing that the general public. Here's one from 2022. They look like this. And right in the opening paragraphs, as I've cited in the brief, they say that this should not be used. This product and its authors do not define usual customary rates and make no recommendations about UCR use. So he uses this book because it has, by CPT codes, it has various prices of what are they? The 50th percentile, 75th percentile, and the 90th percentile. And he uses these as his source, and he comes up with costs. Okay, so his hearsay is not admissible. Therefore, his future projections are not admissible. And the question he answers is not what costs is Peyton Jones more likely than not going to incur in the future for the reasons of her stroke. He answers the question as to what needs are and what they can cost. That's not the issue. So we've brought our motion to strike his testimony, and we've based it upon the many things that the many cases that have struck life care planners for using this very kind of source, an inadmissible source. And here's where it ties in with the other motion with Dr. Houseworth, who is an economist. Plaintiff's disagreement with Dr. Houseworth is she didn't price the Huckworth plan. Well, of course she didn't, because we don't think it's admissible. Number one, we think it's wrong. Number two, we think it's there to mislead the jury. He even uses the 75th percentile, and which using an inadmissible hearsay source and projecting cost based on what 74% of healthcare providers don't charge is, in my estimation, a legal reason for the court to say, look, this the source you're using, your testimony can be no better than that source. And that source is inadmissible. That's what we're saying. And paradoxically, the plaintiffs in the Houseworth motion say, well, we can't introduce cash prices, which I find to be more than ironic. It's what the plaintiffs are suing for, right? They're suing for cash. So if you have no insurance, if you have no ability to pay for something, all you can pay is cash. And that's what we used from the University of Michigan website on the same CPT codes, coming up with very different numbers. Very different numbers. If you use Dr. Houseworth's or Dr. Are they both H? Yes. Well, that's going to be a problem for me. If you use Dr. Huckfeldt's plan and you project it out as their economist does, then you say the future care costs of Peyton Jones over her lifetime are going to be $73 million. The average cost of taking care of a child with cerebral palsy in America today, according to the CDC, whatever anybody thinks about the CDC is a data source that is providing government statistics. It's admissible in court. They say the average cost in 2024 dollars is 2.5 million, reduced to present value. So if you reduce Huckfeldt's report to present value, it's 13 million. The error rate from the median is 520%, 550%. I variously wrote it because I came up with different percentages to the same calculation, which is was a problem for me in elementary school. But it's still wrong. The average error rate should be no more than 5 to 10%. And this life care plan of his, for that reason, is, we think, inadmissible because it's fatally flawed in the pricing. And if you use the wrong pricing, then the report that you come up with is going to be wrong. And we say the report is wrong and it's inadmissible. And we've cited 2 other cases where that result has been achieved or has been confirmed in various jurisdictions. I don't think we have one yet in Michigan on this, but we may in the future.
Okay, all right, thank you. Ms. Walsh, if you want to address responding to the motion with regard to Dr. Huckfeld, and we kind of are addressing the Houseworth motion as well at the same time here. So if you'd like to provide your argument as to those two, please.
Well, okay, I'll make my first statement and then you can tell me if you want me to address Houseworth. Both of the
Okay.
statements that Mr. Valatutti said were our arguments in Houseworth are not. Neither one of those are arguments that we've made about Dr. Houseworth's opinion. So if you want me to argue hers now, I can, but that's a completely different issue. Didn't involve either of the two things that he said. So you can let me know if you want me to argue that now, Judge, or wait.
Yeah, now you've got me curious. So why don't you go forward?
Okay, so let's start with Dr. Huckfeld. I'm not in their brief, defendants state that Dr. Huckfeld is not a pediatric anything. And Peyton Jones will only be a pediatric patient for another 12 years. The vast majority of her life, she'll be an adult. And if I were to put forth a pediatric anything to do a life care plan, I don't know how they would know what the patient would need after the patient turned 18. Nobody that's in the pediatric profession that I'm aware of does life care plans. I've never seen one done by anybody on the plaintiff or defense side. They are all done by people who know both pediatric and adult patients. So I think that that's pretty clear that Dr. Huckfeld, unless you have other questions, Dr. Huckfeld is abundantly well qualified to testify in this case. And despite the discussion about Dauber hearings, I'm not aware of any Dauber hearing. I think he's testified in hundreds of cases as a life care planner in the last 15 or 20 years and has never, as far as I know, has never even had a Dauber challenge. And I have to go back to the study that the defendants talked about, this $2.5 million, Judge, because you're going to hear this from me more than once today. And that is, we're in the 21st century and we're a quarter of the way through it. And we're now talking about data that's 75 years old. And that's not an appropriate data source to use for now. The article about the 2.5 million was from the 1990s. That's when the article was written. It compiled numbers from the lifetime of CP patients. So that means it went all the way back to the 50s, 60s, 70s. It had to have in order for them to get these lifetime numbers. And so, Judge, I think that you would agree and maybe could take judicial notice that back at a time when cars cost $1,500 and a gallon, how about a dozen eggs cost 3 cents? Times have changed. So something that was published back in the mid 1900s, the mid 1990s, is not relevant today in terms of what the actual cost is. So this $2.5 million number is completely irrelevant to today. More importantly, that article only addressed 4 different types of kids, people, not kids, because these were adults. This went all the way to adulthood. And they didn't address kids with hypoxic ischemic encephalopathy or a variety of other brain injuries. Let's see. I think in their brief, Mr. Valatutti didn't mention it here, but in their brief, they talk about Dr. Huckfeld not being aware of this study from 1996 or 97. In our brief, we responded, he's well aware of the literature. He knows exactly what the literature is. He said he's read it, but things that are that old, he doesn't take into account. He also was asked a lot of questions in the brief the defendants cite to him not knowing about special needs trust. Well, that's not something that he would address because that's a post-trial issue. Moving on to what they spent very little time on their brief on, but most of the time today. Mr. Valatutti talked about the fair health, and maybe he did one of these things. Well, Mr. Valatutti, I think, knows that every order that he submitted striking any kind of a database was all fair health. And fair health is not even close to what the PFR is. Fair health is something that insurance companies put together to try to set rates for things, I believe. I know it was composed by insurance companies. It was not all inclusive. It wasn't designed for determining costs of anything. The PFR very clearly is a compilation of all of physicians' fees and therapists and healthcare professionals based upon their geographic area. So based upon their zip code, what a office visit to an internist costs in the zip code where Peyton Jones lives. It's a compilation of data. And as the court saw from our brief, in fact, the courts in Michigan have ruled that compilations like that pursuant to MRE 803-13 are not hearsay. So this is not a hearsay document. This compilation of, and the Michigan Court of Appeals ruled on that in Morales versus State Farm, which we cited on page 13 of our brief. So this is not a hearsay document. This database is not hearsay under 803, and it's 803-17. And there's also a federal rule, 803-17, that is exactly the same as the Michigan rule. And this database has been held, or this database and other similar ones have been held admissible around the country. So I don't think there's any question that this is an admissible source. In addition to that, as we cited in our brief, Your Honor, the PFR is used by life care planners all the time, and there's statistics for it to show that it is used as a routine part of life care planning. So this is, if you were looking at Daubert, this is exactly what would meet the Daubert criteria to be admissible at trial. So none of the arguments that they say that supported the striking of any of Dr. Huckfeldt's report, and I would add the PFR is only one of the sources that Dr. Huckfeldt used. It wasn't the source he used for everything, but nothing that they cited goes to that issue. And I can move on to Houseworth now if you'd like.
Okay, yes, please.
Okay, so there are two issues we have with Ms. Houseworth. So she is an economist. The first issue is completely a legal issue, and the defendants did not address it at all in their briefing. The standard for recovery in Michigan, and this is well settled in the Michigan Supreme Court and the courts of appeals, is loss of earning capacity. Ms. Houseworth said, well, I didn't think that was a good standard, so I used loss of work life expectancy. So in other words, she took years and amounts off of it, calculating what she believes Peyton would have earned, not what she could have earned. So I'm going to give you an example. If somebody did took my income and my work life, and instead of doing what my earning capacity was, for women, they actually subtract 13 years from your work life and say, well, women are likely to be out of the workforce for that many years for childbearing and all these other things. So I'm still waiting to get my 13 years, Your Honor, but it's clearly not appropriate. And the standard is absolutely 100% loss of earning capacity. And this witness should not be allowed to give testimony about something other than that, just because she doesn't like the standard we have in Michigan. It's well settled law in this state. I'm not sure. I mean, I know defense experts keep doing this, and we always ask them, did you do loss of earning capacity? Because that's what goes to the jury in Michigan, and they don't even do it. So we're asking that her earning capacity, her earnings numbers be stricken because they don't follow the law in Michigan. That's argument one. Argument number two is that Ms. Houseworth, so both the plaintiff's expert and both of the defendant's experts, so everybody who opined on the issue in this case says that Peyton Jones will need assistance in the home as an adult, as a child and an adult. Peyton Jones is not potty trained. Peyton Jones needs assistance with basic activities of daily living. She doesn't speak very many words. She's learning more words, and she's learning to use alternative language like sign language and artificial intelligence so she can communicate. But she has a number of deficits. Our second concern with Ms. Houseworth is Ms. Houseworth said she doesn't need any help in the house. Period. She's an economist. She has no basis to make that decision. And both of the defendant's own experts admitted that she will need help in the house. So our two arguments are she should not be allowed to present a life care plan that says this child does not need any assistance in the home because it's contrary to the defendant's own expert and our expert. And Judge, your own life experiences can come into play that somebody who can't even go to the bathroom on her own probably will need somebody in the home to help her. So those are our two arguments with Houseworth. She basically, number one, decides that she can an economist can supersede the opinions of doctors on this one issue, and that she doesn't use the proper standard in Michigan, which is loss of earning capacity.
Okay, thank you. Mr. Valentini?
Okay, so I thank counsel for clearing up my confusion. Yes, Dr. Huckfeld uses the PFR, and like Fair Health, the PFR says in its disclaimers, your decision-making you should consider all relevant factors. This product and its authors do not define UCR, usual customary rates, and make no recommendations about UCR use. That's what he used. It's inadmissible hearsay. With regard to Houseworth, she did include homemaker services in her report. It's on page, this report is voluminous, and I can see how counsel could miss it, but it's on page 4 of 16 of the appendix, table A1, where she has homemaker services starting at a certain age and continuing on for life. And that's what Dr. Kolevson, who is our pediatric neuropsychologist, who examined the baby along with Dr. Curtin, or not the baby, but Peyton is now a young girl, says she doesn't need home care attendant. She needs home care services, and it's in the report. What can I say? It's there. What they say is not there is there. And then with regard to her opinion, with regard to earning capacity is the subject matter of earning capacity is governed by the wage rate and the reasonable what with reasonable certainty is the individual plaintiff more probably than not going to incur as earning capacity loss. So what the plaintiff is saying, you shouldn't put in the averages of the calculations regarding earning capacity that occur in real life. Stated simply, the plaintiff's expert uses a linear methodology in defining earning capacity, and they say it goes like this. So, at this point in my life, I should be making more than I made when I was in my 40s, 50s, and 60s. But that doesn't go along with reality. What happens in everybody's life is that their earning capacity reaches a peak and then it goes down because we live longer than we work. So her testimony is relevant to a loss of earning capacity. It's material and it's consistent with figures. And with regard to the CDC calculations, the CDC calculations were updated by Dr. Houseworth to inform the jury as to inflation since the time. But she also did more in her investigation of the average cost of caring for a child with cerebral palsy. She looked at multiple sources. Michigan doesn't have a no-fault standard with regard to perinatal injury case, but Virginia does, New York does. They have audited reports that are put out every year by the state of New York and the state of Virginia, and they're paying for all the children who have cerebral palsy and all of their needs, and they have averages, and her averages are the same. The CDC averages, as inflated over time, are equal to, and in some cases less than, the audited reports And she addresses all of those sources in her reports. This has been a subject area that's been studied. The only people that don't study the average cost of caring for a child with cerebral palsy in America today are life care planners, because their job is not to determine what the average cost is. Their job is to inflate these damages as high as possible so plaintiffs can get at or near $100 million. So no one in their right mind would try a case, so that they just pay. And that's a problem. And it should be addressed by my successors as time goes on, because it takes a long time for the law to catch up with a lot of things that are done to inflate things. Let me put it that way. And in this case, we're challenging Dr. Huckfeldt's opinions because he used a source of hearsay that's inadmissible. With regard to Dr. Houseworth, she did include homemaker services that are in her report. She included the 3 hours that are put in as homemaker services suggested by Kolevson, and all of these matters are grist for cross-examination, but they don't disqualify they don't disqualify Houseworth from testifying. If they did, I would bring a like motion against their economist, because he uses Dr. Huckfeldt's opinions without studying it as an economist should. And their economist is a pretty good economist. He has, in the real world, identified and investigated the costs of very many things. That's the research that economists are supposed to do. They're supposed to determine what the costs of various things are. He didn't do that. He just took the figures of Huckfeldt and projected them. So his opinion is entirely based on Huckfeldt, and Huckfeldt's opinion is entirely based on inadmissible hearsay. But saying that I saved the court from another motion doesn't mean that the court should be persuaded. The court should be persuaded by the fact that everything Ms. Walsh said is a good and proper reason for her to cross-examine Dr. Houseworth in front of the jury and let the jury make a determination based upon all the evidence, instead of just that the plaintiff wants the court to allow.
All right, thank you. Ms. Greenman, any argument from your side?
No argument, Your Honor. I'll rely on my brother counsel's arguments, as well as all the briefing that I know you've read. Thank you.
Your Honor,
And I did, Mr. Vallet, you get a chance to respond to Ms. Walsh's arguments on Houseworth, but Ms. Walsh, you did not have a chance to respond to the arguments.
I would like to respond very briefly, Your Honor. A homemaker versus a caregiver are two different people. A homemaker is the person who comes in and, like the maid service that cleans your house once a week. A caregiver is somebody who's taking care of the injured person. We've quoted it in our brief, Your Honor, so you have it, what the defendant's expert said she needed in terms of the child, or when she's an adult, Peyton needs an assistant there to take care of her, to help her, not a homemaker. So those are two different things. And she did not account for having a caregiver at all. Second, the whole ruler argument made exactly my point, Your Honor. Whether they agree with what the law in Michigan is, that's a different issue. But the law in Michigan is what you could make, not what you would make. So, like you could still make the same amount you're making in your 40s and your 50s when you're in your 60s and your 70s. You could. They want to say you wouldn't. But that's not what the standard in Michigan is. A very clear legal standard. It's been up several times on appeal, and even to the Supreme Court. It's loss of earning capacity, period, nothing else. We can't, I don't know if the judge knows this, so I guess maybe I'm just going to educate you. There are certain states who have a birth injury fund, and they cover certain things. So if you only wanted to look at what those certain things cost, that would give you one opinion. That would not give you what the total cost of care of an injured person is. And I was offended personally by Mr. Valetuti's comments of trying to get $100 million. And I would point out that I'm sure this court knows if the jury give you $100 million, that means when it gets reduced to present value, it's probably about 17 million, maybe 20. It's not hundreds of millions of dollars. We're not trying to inflate anything. In fact, I talk to my experts sometimes because I think they leave things off, but they, in an abundance of caution, they do leave things off, like having dental care under anesthesia, because you can't drill a tooth of somebody who's impaired because they don't understand what you're doing and they get excitable. So there is nothing about, I'm sure the court, I should not go off on this soapbox. I'm sure the court didn't give that much, hopefully the court didn't give that much credence in this motion. And I would point out, it was interesting that when Mr. Valetuti was trying to say that the motion should be denied as to his experts, he slipped and said it should be denied as to these experts, meaning Dr. Huckfelt as well.
Okay, all right, thank you. Again, I did review both the motions as well as the supporting documents that were provided by counsel as to each of these motions. I'm going to kind of address them together since we've argued them together. First of all, again, as I've done throughout this, I try to take a step back and look at the big picture and what are the overall issues here. And what we have is competing views of this aspect of damages, which I think is, perfectly reasonable and understandable for each side to take the positions they've taken and to arrive at the numbers that they've arrived at. In these types of cases, the plaintiffs are always going to try to have the damages fully expressed by their experts and to come up with for lack of a better term, the highest number that's justified by the evidence. The defendant's experts generally are going to come in with the lowest number that would be justified by the evidence. And those are kind of the competing sides to this. And generally, absent some reason to exclude, I view those as, plaintiff puts on their case, the defendant puts on their case, to the extent that either side's expert and testimony and numbers that they arrive at are credible, to the extent that they have probative value in that they're based on good studies, good numbers, and a good basis. Those are all matters that each counsel, as part of their job as opposing counsel, tries to bring out the weaknesses, both in the credibility and the probative value of each side's experts on issues of damages in this particular aspect of damages. So I think generally, this is a situation where as counsel has alluded to today, it can be grounds for cross-exam, it can be grounds for discrediting or showing why the jury shouldn't trust the numbers that the other side's putting forward through their experts. The question in here is, has either side gone so far beyond that, or is there a legal reason, as argued by Ms. Walsh, for excluding some of this testimony? As it relates to Huckfeld, number one, I don't see why the PFR wouldn't, and his reliance on the PFR would somehow be excluded as hearsay. I agree with Ms. Walsh. I think, under 803.17, I think it's from a legal standpoint perfectly fine for Huckfeld to rely on that as part of his numbers and testify to his numbers and where he got them from. So I don't find that to be a reason to exclude Huckfeld's basis. I also think, reading through the materials, that while there may be, again, fertile ground for cross-exam, fertile ground to discredit some of the numbers that Huckfeld reached, they are based in an analysis of what he viewed as relevant numbers for determining this aspect of damages. So I don't find that anything that Huckfeld came up with is so outside the scope of reliability that it shouldn't be allowed and it shouldn't be up to counsel to bring out the weaknesses through cross-exam. So the court will deny the motion as to Huckfeld. Similarly, as to Houseworth, I'm not convinced that Houseworth is arguing an inappropriate standard. I think there's room for what Hausfeld is bringing out in terms of the loss of earning capacity versus what Peyton would have earned, not what she could have earned. So I don't think it's to the extent that testimony is excludable as being an inappropriate standard of the measure of damages. Same thing with the question over homemaker versus home health care, that type of thing. I really view that, again, the same way I view Huckfeld is it's not so beyond the scope of the type of damages that would be allowed and should be allowed, that Dr. Housefeld's testimony shouldn't be admissible. Again, I think any of the weaknesses are those that should be brought out through cross-exam, and I think ultimately it's going to be up to the jury to decide between the different numbers from plaintiff and defendant as they're qualified through cross-exam to decide what an appropriate award may or may not be if the jury gets the damages. So for that reason, again, the court is going to deny the plaintiff's motion with regard to housework. So the court will deny both of those motions. And then finally, our last motion is with regard to Dr. Worth's opinion on IUGR. And so Ms. Walsh, are you going to be arguing this one as well?
I am, Your Honor. And
Your Honor,
be
I'm
very-
sorry, Ms. Walsh, I'm sorry. Your Honor, if I may interject, sincere apologies. I was just notified that one of my associate attorneys is ill, and I need to just jump on my other computer to check in for a motion that they were supposed to cover. If you don't mind, I apologize. I didn't have any notice of this until about 3 minutes ago.
Okay. Can we continue, or do you want us to wait?
Yep, absolutely. I feel pretty comfortable with Mr. Valetuti's intellect and argument and response. So that's okay. Please go ahead. I'm just going to check in. I might be able to pop right back. I'm just going to mute myself and turn off the video.
Okay, very good. Thank you.
Thank you. Thank you so much.
Ms. Walsh.
Certainly, yeah. As I said, Your Honor, as I started to say, this is going to be a very short argument. So I assume I can tell that you've been reading all the briefings. So the most important thing here, and there's only one issue really that I need to bring up, and that is the defendant's brief is pages 4 through 10 of their filing. Pages 4 through halfway through page 9, they spend 4.5 pages or 5.5 pages going through the history of the definition of IUGR. And they, at the end of it, some of the definitions, they also include information about what can cause IUGR. So I want to make sure our motion is very clear. This expert testified there was no IUGR. What's important is we asked her what her definition of IUGR is. So all of the definitions that the defendants put in their brief are not really relevant because we wanted to know if based on her definition, whether she thought there was IUGR. Her definition is the same as everybody else's. The baby's weight or the fetus's weight is less than the 10th percentile. And that's on page 58 of her deposition from lines 9 through 13. So basically all of those definitions that the defendant gave you are not relevant. Dr. Worth's testimony is, and we cited it in our brief, do you believe there was IUGR? No. She says there's no IUGR. She discounts every single ultrasound, every single note, everything that all of the treating doctors say. And she says because on January 2nd, there was an ultrasound that showed the baby was an IUGR. To her, the baby never was. Now, of course, a baby, even if it wasn't IUGR at the beginning of January, could develop IUGR after that. And every other expert on both sides, every witness in this case has said this baby was IUGR. Now, the defendants do point out in their brief on pages, I think it's 8 and 9, or it might start on page 7, they talk a little bit about what causes IUGR, but that's not really relevant. I don't care about that. IUGR is simply, or FGR is simply a baby that's less than the 10th percentile when they do an ultrasound. The next step after that is why. But we don't need to get to the why because this expert says the baby never was IUGR. And under MRE 702, she has to use the facts that are present in this case. And she's the only witness in the entire case who says this baby never was IUGR. And there is nothing about that that will be helpful to the jury. The defendant's other OB expert, their MFM expert, they both say there was IUGR or FGR. FGR is the current terminology. IUGR is the one that most of us know from a long period of years of being called that. But she is the one expert in this case who took the position that she's just going to disregard all of the ultrasounds after that. And that's not appropriate for an expert witness in a case, Your Honor. And it would only confuse the jury at best. I mean, could outright create prejudice in this case if there's a witness allowed to ignore the evidence in the case and give testimony that's contrary to it.
All right, thank you, Mr. Valatutti.
Well, what I think a plaintiff is doing is confusing terminology. In fact, Dr. Worth, in her testimony on page 82, which the plaintiff has cited in their papers, she said it's her testimony that there were concerning measurements from the radiology department. In any case where a baby registers in a ultrasound below 10%, the baby has to be followed. No one has said this baby wasn't followed in this case. In fact, more than 21 obstetrical visits were scheduled, and most of them were complied with. And during that period of time, they're trying to determine, is this baby, they're asking this question, Judge, and it's an important question that the OB has to answer. Is this baby just small because its relatives are small? That would be constitutionally small? Or is this baby have a problem? Is there a problem in the placenta, in the cord, or in the mother that is affecting the baby's growth in utero? And so you follow the baby through the course of 39 weeks. And during that period of time, you're monitoring for the baby's heartbeat, the baby's movement in the utero, the blood flow, the amniotic fluid measurements, and the fetal growth. And what Dr. Worth is answering in her thing is that after you do look at this whole case, this is a baby who didn't have an obstructed cord, didn't have abnormalities of an observable nature that were relatable to an endemic problem in the uteroplacental flow. She never showed any signs of pathological problems that was interfering with growth. In fact, when she was first diagnosed with suspected UGR, and it's always suspected, you have to keep it up. It's a common diagnosis. You suspect it and you monitor to see if it gets worse. That's what you're looking for, because if it gets worse, it's pathological. And so she's agreeing not only with the facts of record in this case, but she's herself saying, no, this baby was not IUGR. She was born at 5 pounds, 12 ounces. Her mother was 6 pounds, 2 ounces. She's congenitally, constitutionally small. She did not have pathological intrauterine growth restriction. And that's what our experts are going to testify to. And that's in the record. Dr. Miner's record states this baby was constitutionally small, not growth restricted. In fact, the February 4 ultrasound film reread by Dr. Manning, our expert, he's going to come in and say she was above the 10th percentile on February 4th. And so I think plaintiff is just quibbling with terms. The issue is whether or not there's a problem with the unit that's providing blood and nutrients to the baby. And it's Dr. Worth's testimony, there wasn't.
All right, thank you, Ms. Walsh.
Yes, what Mr. Valatutti started saying was first of all, you ask, is this baby small? And then you ask, why is the baby small? I'm talking about, is this baby small? And the defendant's expert said, no, this baby was never small. This baby never met the criteria for IUGR when everybody else said she did. And I trust you've read her deposition, Your Honor. So it's very clear. She just disregards everything, and that's not allowed. Whether the baby, so in terms of IUGR and fetal growth restriction, the only parameter is the babies less than the 10th percentile for babies of that gestational age. It's not why is the baby small? Is it good that the baby's that small? Is it bad? Is it normal? The first step is the baby small? The second step is why is the baby small? But with this witness, and every other witness agrees, you get to one of the issues in this case is why is the baby small? But not for this witness. For this witness, she said the baby was not small. And I'm going to sidetrack just for a minute for what Mr. Valatutti just said about what Dr. Manning said about an ultrasound that was misread. After the close of discovery, after all these motions were filed, after all the deps were taken, yesterday, Mr. Valatutti sent us an updated disclosure that said, oh, my experts have now read all these things again, and now their opinions are different. So that's going to be the subject of a motion to strike because, I mean, he's basically tried to change yesterday tried to change the whole theory of the case. But for purposes of today, I would ask that statement be disregarded until we can address it with the court. But for this witness, she says this baby was not small. Excuse me. It's not a question of why the baby was small. For her, it's the baby didn't even meet the definition of small, which she told us what the definition was. The reports say she was wrong, say this baby was small, and she just says, I'm going to disregard these reports. And that's not an expert's job. The expert has to take the facts in front of her and use those in the case. So this particular witness, unlike all the others, failed to use the facts in front of her and said this baby wasn't IUGR when everybody else said the baby was IUGR. But I mean, I'll go with what Ralph says. It doesn't matter to me, but it was normal. The baby was small, but that was normal because it was constitutional. So the baby had IUGR constitutionally small. I understand how you could make that argument. There is no way to make the argument the baby was not small, was not IUGR.
Okay, all right, thank you. I did read through the Worth deposition. I looked at this motion last, and by the time I read through Dr. Worth's deposition, I had already read through all the other expert depositions, and perhaps maybe I thought I was overconfident, but I felt like I had a really good understanding of IUGR, at least as good as a lay person who's legally trained and not medically trained could have, based on all this discussion of it and all these records regarding it that I had reviewed prior to Dr. Worth's deposition. And frankly, I was surprised. And I tend to agree with Ms. Walsh that Dr. Worth seems to either not pay attention or not give proper credence to all of these other ultrasounds and measurements that were done, and in my view, looks at the January 2nd ultrasound that was done by the MFM that showed, I think was 27%, which was a vastly different number than any of the numbers that had been obtained before that and after that even. I think the highest number that I recall seeing after January 2nd was 9%. There was some question about whether or not that would justify early delivery or not under the others, given all the other factors that are present. But reading through all the experts, including the defense experts, until I had read Dr. Worth's testimony, I didn't really think there was much question that Peyton was IUGR. And so, again, I agree with Ms. Walsh. And again, viewing this as the court's gatekeeping, and the parties can see from my previous rulings, generally, I believe it's a matter for the jury to decide how credible and how probative an expert witness's testimony is. But in this case, I really do view Dr. Worth as not haven't given adequate weight to the actual testing that was done, measurements that were done, and gave improper weight to one study, which again was vastly different than all the others. Could have been affected, as I think testified to by some of the other experts. It could have been affected by the calculation of the due date in terms of how they calculate the percentage. It may not have been accurate. So for those reasons, I find that Dr. Wu's testimony should be excluded, and the court will grant that motion.
Thank you, Your Honor.
What I'm going to do, because I've had different rulings in favor of some defense, some plaintiff here. I'm just going to ask counsel to confer on a stipulated order as to form, given the court's rulings today, and then submit that. If there's any issues with that, then just notify the court and we can schedule it for a hearing to resolve the order. Ms. Walsh, do you think that'll be an issue in terms of preparing an order with a stipulation as to form on the court's rulings today?
Not at all, Your Honor.
Mr.
Just to
Bell,
clarify, though, you want one order with all the motions?
Yeah, I think if we could put it all together as with stipulation as to the form only.
Okay, we'll prepare that and send it to Mr. Valatutti.
Mr. Valatutti, do you see any issue with that?
I'd like a separate order for Jacqueline Worth's finding.
Okay. Any objection to that, Ms. Walsh?
I have no objection. I would do them all separately or all together or mix half and half. I don't care. But we can still prepare them all and send them to Mr. Valatutti to approve as to form, and we'll separate the Worth motion out.
Okay. All right. Very good. And then one thing I'm not sure about, did we also have a status conference set for today?
We did, Your Honor. Yes.
All right. I do see that on the docket. So given the rulings today, I'll just start with plaintiff's side in terms of how we want to go forward from here. Any suggestions for scheduling moving forward?
I don't, Your Honor, other than the fact that we are going to file a motion to strike this new opinion that the defendants have. I believe this case is trial ready, and we would like a trial date, and I think we need a date for filing motions in limine, and we are good to go.
Okay, Mr. Valatutti.
Motions in limine. Let me think for a second. I think motions in limine are next. And I don't believe there's any further discovery. So motions in limine, final pretrial and trial.
Okay. How far out, again, starting the plaintiff for the trial? I want to get a time frame for the actual trial and then kind of work backward from that. So Ms. Walsh, how far out should we set the trial?
How far, I'm sorry, are you asking me how many days we'll need for trial, or are you asking me when a good month for trial would be for us?
Yeah. What, not the duration of the trial, but
Okay.
the interval between now and when the trial would be scheduled.
Okay, so we would be happy with a trial date in April or a trial date in August. That would fit in with our trial schedule that we have moving forward. We have one trial in September, so anytime, October or beyond, we're also available, but obviously for our client's benefit, we would prefer it sooner than later. So April, and I might have misspoke, April, June, or August.
Okay, it's definitely not going to be April because I've got some lengthy criminal trials that I'm going to be trying this spring that are going to be week-long affairs. So it would be the summer or early fall, Mr. Valatutti.
Judge, we really do need Ms. Greenman for this.
Okay.
I can do August for sure. Yeah, I can do August.
All right. In terms of duration, Ms. Walsh, how many days of trial do you believe?
So to clarify, do you do, how many days a week, and are they full days?
They're full days, and, you know, the first day of trial is jury selection, and then once we have a jury, we go right into openings, so I don't set aside just a separate day for jury selection. And I do full trial days, 9 AM to 5 PM.
5 days a week?
Yep,
Then I would assume we would be done, if not at the end of the first week, we might take 1 day into the second week, assuming, and depending on how long jury selection takes, but I would think that our side could put in our case in 3, maybe 4 trial days at the most, but more likely than not 3 to 3.5.
okay. All right, Mr. Valatutti, your thoughts on that? Are you able to opine on that without Ms. Greenman?
Oh, I can opine on that without Greenman, Ms. Greenman. The 5, so that's 5 days on the outside for plaintiff. I'm adding in the jury selection day as in addition to plaintiff's estimate of 4 days. And so we have Otsego. I should think that 5 days plus 1 day for argument on jury instructions. Are you going to decide jury instructions before the proofs are in, or are you going to do it after?
I'll have both sides submit proposed instructions prior to the trial date. Usually I just address final instructions once the proofs are in. But if it looks like there's some real major differences in what parties have submitted, then we may need to have a hearing ahead of time on it, so we don't waste jury time arguing over it.
I would be shocked if there were very many disagreements about jury instructions, Your Honor. I would think we could handle them at the start of a lunch hour, but
Yeah, I've never had to schedule separate hearings just to resolve jury instruction issues, but I mean, it's the first time for everything, so.
Well, I've had long jury instruction arguments, but in any event, I would say 5, 6 on, and the 6th day is closing argument and any housekeeping that has to be done before the jury is charged.
Okay.
So that's 11
All right.
days, I guess.
Okay. So what I typically would do is set, once we have the jury trial date, and we'll be looking at more of the either probably August or October timeframe. What I would do is set it for what I call a trial preparation conference about 30 days prior to the trial date, where that would be a motion in limine cutoff. So they can be filed at any time, but they would have to be filed and heard no later than the date of that trial prep conference, so that we'd have those issues resolved at least a month prior to trial. I use that conference to discuss, you know, just kind of nuts and bolts. Parties need to use courtroom technology. If we need to, you know, adjust the courtroom so that projectionists can be brought in, you know, all those different kind of things. Discuss the composition of the jury. You know, how many jurors will constitute a verdict, so forth. All those things would be addressed in addition to any motions in limine that hadn't been heard, would be heard on the date of that trial prep conference. So that's how I would schedule this going forward.
Your Honor, is that final conference in person, or can it be in person if we would like to be there and see the courtroom and start planning that so we know about our technology?
Yeah, absolutely. We can set that in person for sure.
So as I understand it, Your Honor, you're going to pick out a period of time for the trial somewhere between August and October. I'll advise Ms. Greenman to forward to the parties any commitments she has in that time. And I'll
Okay,
have her
that would
do
be
it today.
I'll say, just to be clear, I have a trial in that's currently set in September. I don't know if it's going to go or not, but that's why I said August and October, not August through October.
Yeah, I have it as August or October.
Okay, good. Thank you.
Okay, so yeah, Mr. Delatucci, if you can have Ms. Greenman notify the court if either August or October is bad for her, and then if it's only one of them, we could pick the other. If it's both, then we'll have to go from there. And then the court will send out notice of the date and time of the trial dates. I'm going to set aside 7 days, 7 court days, just in case. I'd rather have a little more time built into it than have another trial scheduled right on the heels of that and then have an issue of running over. And then I will also send out the notice of the date and time of the trial prep conference. The order will reflect that that is, again, a cutoff for motions in limine, so the parties can file those at any time. But again, if they're not filed and heard by the date of that trial prep conference, they'll be deemed waived. And then, of course, any other motions, whether they're dispositive or not, as you mentioned, Ms. Walsh, can be filed at any time in the interim.
The dispositive motion cutoff is already gone. Are we reopening that?
Okay, well, if it's gone, it's gone. I'm not reopening anything. So
Thank you, Your Honor. Just checking.
I don't have the scheduling order right in front of me. So yeah, if we pass that date, then we would just be dealing with motions related to the trial.
Okay. Thank you, Your Honor.
Okay. All right. Ms. Walsh or Ms. Sikorsky, anything else I can address for your side today?
Nothing else, Your Honor. Thank you.
Mr. Delatucci?
Nothing, Your Honor. Thank you very much for your time and your attention. You've been very charitable.
Okay, thank you. And everybody have a nice weekend.
Thank you.
Everybody's
You